Hey, welcome to On the Chain. This is Jeff here with co-host Chip. Tonight, we have an amazing show for you guys. We have none other than John E. Deaton with us. We're going to talk and dig into the SEC v. Ripple case. We're going to talk about a little bit, more in depth than what you guys might get if you're just, communicating via Twitter. So there's going to be some Q&A. We're excited to bring John in here. And man, there's so much to cover, Chip.
Let's get this started. Let's go.
Welcome to On the Chain.
And here we are. Without further ado, drum roll, please. Let's bring in John E. Deaton. John, welcome to On the Chain. Great to have you back. One of our favorite guests. And again, always thrilled that you keep coming back. So when we ask you
guys, thanks for having me. I appreciate it. I know we got a lot to talk about tonight.
We certainly do. We certainly do. And so if you guys have questions out there as well, you can throw them in there. We'll keep an eye out for that. But we have some prepared questions for John as well that we'll get through, and we probably should just get this puppy started. I think the biggest thing right here, I guess the big question on everybody's mind, and there it is right there. Why did Ripple agree to a compromise with the SEC? Not only Ripple, but also Larson's and Brad Garlinghouse's attorneys as well.
Well, it's a great question. And let me say this, reasonable attorneys are going to disagree. Okay, so Ripple had two choices, and I don't speak for Ripple. Everybody knows that. In fact, I personally would have chose a different path, and I'll tell you why. But I guarantee you that if you had 5 Ripple attorneys and they voted, it would have went 3-2. Like, fight, and we can't get any worse. Oh, but it really can get any worse, but it's still worth fighting for, and it came down to a decision. Look, I personally probably would have fought it because I would have then, and I say that selfishly because it would allow maybe for XRP holders to write a letter and participate and talk about the damage this is being done to retail holders as well. And I'm sure Ripple and their attorneys thought about all this, and they came to the decision that it is better to go with certainty. And I think that the Ripple lawyers probably told Brad Garlinghouse and Stuart Alderati, listen, you got a 50% chance of getting a couple months early in the grand scheme of things, and a 50% chance of it being a lot worse. And when you're faced with that decision, you may have to go with the certainty. Now, for example, everybody trusts Jimmy Fallon, right?
Hell yeah.
Jimmy tweeted, I don't speak for Jimmy, but I know I saw his tweet. He said this was a good move. And Jimmy is on Team XRP holders, and I'm on Team XRP holders. And so that just goes to show you, I would have said maybe we fight it. Jimmy goes, no, this is probably the best decision. And so everybody needs to understand that people on the same team could disagree. And I saw Stuart Alderati's tweet. And listen, Stuart, I don't know Stuart, and I know his background. He's like a New York litigator, right? Well, you're a New York litigator. It's not like you aren't a fighter. And so his instinct could have very well been, let's fight this as well. But at the end of the day, you know what I mean? When you're faced with that decision, it's a tough call. What the problem for me, and I say my bias, is because I know the impact it has on people. And I know that people have their property has been seized, right? And you want that information to get to the court. But also, to be fair to Ripple, what's the one thing they've consistently lost, right? When they objected the first time there was a 60-day extension on expert discovery, they lost that battle. And when I wrote a letter to the court, they wouldn't even consider it. Remember, I wrote a letter saying to the judge, will you please consider XRP holders' perspective? And the judge denied that request that they would consider it. So Ripple may have even contemplated, hey, if we fight this, Deaton and the Amicus people can come in but they already got shut down. We keep losing on scheduling. Let's take, the bird in the hand and go forward. And so there was a really good chance, and I put it at 50%. That's a pretty significant chance that they could have done worse. And so as much as I say I want to fight, I could have been talked into this decision as well, if I'm being 100% honest. You know,
But that's because go ahead, Jeff. I was gonna say
I was gonna say, yeah, I was just gonna say, does the way this is continuously unfolding with all the delays, on the part of the SEC, it just seems like there's, something else that's happening behind the scenes that maybe we're not privy to, and that the longer this goes on, does it then benefit? Which party does it benefit? To me, it seems the longer this drags on, the more it potentially benefits the SEC.
Yeah, I think we're seeing why a lot of people don't fight the SEC, and we're seeing why they steamroll everyone because, as far as I'm concerned, they have the facts against them and they have the law against them. And so when they can't win, how do they try to win? They just delay. And it certainly could be, this is their leverage, right? What leverage do they have if there are talking settlement? And there could be zero talks of settlement, right? I have no idea. I don't have any insight on that. But if they are, this is their leverage. We can continue to pound you on the calendar and drag it out. And so I agree with you. It favors the SEC. It certainly gives them the most leverage. You know what I mean?
Yeah, exactly. So what about the LBRY case? Because we know the LBRY case, I saw that Jimmy Filan had tweeted that out as well. What do we think as far as that? That looks like it potentially is going to conclude prior to the SEC Ripple case?
But there's no doubt if the schedules stay the way they are, it's set. There's no doubt it will, because I was disappointed just like everyone else. And listen, I've been in court for 20 years and I'm used to delays. And this was even an excessive delay for me because, I don't think you need 3 months to respond to a brief, to be honest with you. We have August with the initial briefs and the final briefing in December. To me, that seems excessive. But so I was just as disappointed as everyone else as far as the delay. But with LBRY, yes, because we're not going to get a decision until probably best case scenario, if it doesn't settle, a judgment ruling from Judge Torres will be at the end of March. Because if the final briefing, guys, is in December, do you realize how the magnitude of the briefing that's going to take place in this case? And we got to talk about these Daubert motions as well, which may have played into why Ripple agreed to the scheduling order. And if all the briefing is in, let's say, just prior to Christmas, there's no way that any judge, and this isn't Judge Torres's only case, right? She has big cases in the Southern District of New York. The quickest anyone could think of would be 60 days, and that's way too quick. So best case scenario, you're looking at 90 days from the time the briefs are in that you're going to get a decision from her. It could be longer. There's a reason why they in federal court have that 6-month reporting rule, right? It's sort of to keep judges honest. And so best case scenario now, you're looking at a decision from her at the end of the first quarter of next year. And so the LBRY decision probably will come down, obviously, before that. And
that LBRY case has been going on, 4 years? So
well, including the investigation. It actually was filed in March after the December that the Ripple case was filed. And so it's going to conclude, sooner, even though it was filed later.
But they're also, they're also looking at fair notice too, right? I mean, isn't that one of their defense potential? Because they put up fair notice, and let's suppose the ruling comes down and says, well, for all these years you never, and they were communicating with you, they were cooperating. I mean, that's what Jeremy Kaufman has come out and said. Yeah, here we are, kind of stupid, but yeah, we thought we could go to the SEC and tell them what we're up to, and they changed their tune on that at a later date.
Well, this is a kind of a thought that I had, which is we know that the SEC did not move to strike the fair notice affirmative defense that LBRY pled. And LBRY basically did what Ripple did. And of course, the thought is they have a different judge, right? A judge who denied them being able to depose Bill Hinman the way Ripple was able to do it. A judge who has struck down some other things favorable, in the favor of the SEC. And maybe they're hoping they'll get a decision from that judge in New Hampshire that, strikes down the fair notice defense or rules some kind of ruling that it's not applicable or something like that, so that they can then try to use that as persuasive authority with Judge Torres. That is perfectly a strategy that would employ. Now, maybe I'm giving them too much credit, because that is a good strategy, quite frankly, and they haven't been really that strategic in this case, and I think they've been very transactional in every argument. But that's certainly something that could play into hand. Now, if that happens and the judge in New Hampshire says, the fair notice defense isn't a persuasive defense and rules against LBRY, that doesn't mean that Judge Torres will rubber stamp it. She can completely ignore it. There's different law. There's a different circuit. Southern District, New York is in the Second Circuit, right? And so there's, but it certainly would be one more bullet that the SEC could throw at the judge.
And it seems like, overall, we have two significant cases in front of the crypto community at large right now, with LBRY and then obviously with the SEC. And so if we get some sort of an outcome on LBRY, which puts us in an interesting position, as you're mentioning, to where that, may or may not be utilized in, further argument. And so really now there's so much to win and lose. Obviously, we all know that with the outcome of the SEC v. Ripple, which is that potentially another reason for delay. Maybe there's a political element that we're, forgetting about, that we always have to continue to remember, that we're going to also have going into November. We're going to have a complete changeover of the House and Senate. And so maybe at that point, we'll also have a little bit more, a more favorable climate for regulatory clarity in this space. Not saying that.
No, you could. Obviously, the executive order is still out there hanging over, and when they come back, when are they supposed to come back in September and report or something like that?
Supposedly, yeah.
But here's the reality. It is possible that there is some type of executive order that comes down before a decision by Judge Torres on summary judgment comes down, absent a settlement. And so there's no doubt that we're not privy to everything, Jeff, that you're talking about. And there could be things happening behind the scenes that, we're just oblivious to, that are impacting these decisions. But, in this particular case, as we were talking about Daubert, for example, the SEC could have insisted that, well, we're going to have a different deadline for the Daubert motions than we are the summary judgment motions. And that alone could kick this case 2 months. And so, anyways.
If you could just, for people, just explain a little bit of what the Daubert motion is.
All right. A Daubert motion is very easy. It relates to expert testimony. And a Daubert motion is when one side moves to exclude either all of the testimony of an expert or partial testimony of an expert, right? So, for example, we know that there's a Dr. Metz who had a Metz report and a supplemental report, and you could attack his methodology. Let's say that he's going to testify that every time Ripple announced a favorable partnership or something positive, that it impacted the price of XRP. But let's say that's his ultimate opinion. Well, Ripple could say that his methodology on how he arrived at that opinion is what we call swag, a scientific wild ass guess, right? And so that there is no scientific or mathematical foundation for it. Or for example, in the Telegram case, there was an expert, Patrick Duty, who testified to what reasonable gram purchasers were. Well, if he's going to testify in this case, or someone like him, as to what the reasonable XRP purchaser would have relied on. They could possibly attack that. And so very detailed, massive briefs that are going to be related to Daubert. And that's not even summary judgment. That's just the Daubert motion saying, Judge, you need to exclude this expert, or you need to exclude this part of the expert's testimony. So that's what basically Daubert is.
Got it. Thank you for that. Also, too, this is another big one people have been talking about. Can we go after the SEC or Jay Clayton or Bill Hinman personally right now?
You could, and you'd lose.
Okay, so let's get
and all I'm saying by that is, listen, if I could file a case, I would, right? They have sovereign and qualified immunity in their personal position. And as much evidence that we've uncovered about the conflicts and the appearances of improprieties, I'm telling you, it's not enough unless you can get subpoena and you can get emails and you can get all those types of things, right? As bad as it is right now, it's not enough to overcome qualified immunity attacks. And what would happen is, imagine if a judge looked at it and said, nope, qualified immunity, you don't have a smoking gun. All you have is appearances, and you have things, maybe there were some conflicts and there should have been some disclosures and there should have been some recusals, but that's not enough to get past the government and sovereign and qualified immunities that we attach to our government agencies. And so if we rush that decision, then they get a ruling from some judge. If I did it in Rhode Island, or I know Fred was doing it in Arizona, then they could get it dismissed too quickly. And then they would be able to say, look, a judge looked at this and threw it out. We might even be able to get an investigation. And Fred, to his credit, agreed and said, let's wait, and we're going to all revisit this at the appropriate time. So I know people want justice. And, I'm telling you, the best opportunity that we have is that we have to get inquiries from the congressional leaders and Senate leaders on the banking committees. If we can get those inquiries, it can lead to an investigation. And once that happens, then trust me, I'm very confident we're going to find those things that are going to help us overcome those obstacles.
So that means that we have to wait till after November to work on something like that, to get some get a more favorable climate.
Unfortunately, because I've spoken to 7 or 8 Senate and congressional offices. I've spoken to Congressman Warren Davidson personally. I've spoken to several senators, chief of staff, and things like that. And the Democrats right now control the hearings. We all know that, right? So on the Congress side, Maxine Waters controls what we're going to have hearings on. And they're just not going to take up valuable time to investigate one of, Gary Gensler's SEC, right? They're just not going to do it. So what we need is that to happen. We get different leadership, and we have people like Warren Davidson, who did tweet. He replied to a tweet that was about these conflicts of interest, and he said, quote, "Sounds like a good hearing topic." Right? That's big. That's huge. Big. I know it's not what we want yet, right? We want justice now, and we want investigation today, but that's huge. And so we just have to be patient. And I think if we play the long game, then I think we can do some damage to these people who got away, who think they got away.
They did.
That's right. It. Yeah. So John, a follow up to that idea and that notion. So now we have, all of that going on. We have this big delay with the SEC v. Ripple. How does the delay and all these commotions that are going on right now, how does that impact the XRP community, case against the SEC?
Well, a lot of people have hitting me up on Twitter saying, as Amicus counsel, can I do something about this scheduling? And the answer is no. And this is why in the beginning, if you remember, I filed a motion to intervene to be named a defendant right, to be an actual party to the case. Because when you're an actual party to the case, then I have to be involved in all of these things. I didn't ask to be amicus. I asked to be amicus in the alternative. I said, this is what we want. We want to be named defendants. If you won't give us that, then at least give us the amicus curiae. And the judge went with the amicus curiae. But if I thought that I could write a letter to say, Judge, throw out this joint proposed scheduling order and not alienate her, I would do it. But from her perspective, both Ripple and the SEC, the two parties of the case, have come to her and said, we agree with this schedule. And if the defendant, whose entire business is at stake, is agreeing to it from her perspective, then the amicus guy needs to sit down and shut up. I mean, that's in essence what would happen, and it would alienate her. And I'm not going to alienate her because I'm about to ask for certain things, right? Because I have to write an amicus brief. Well, in order to write a meaningful amicus brief, I need to review things that aren't in the public domain, right? That are not put on the docket to the public to see. Certain evidence that's being presented. For example, these experts, if they're going to talk about XRP holders, I have to be able to read that testimony in order to write a meaningful brief. And so what we're doing next is I'll be reaching out to both the SEC and Ripple very, very soon, privately, asking them to what is their position going to be. You know, is the position of the SEC going to be, Deaton, you're not entitled to anything? You're not allowed to see anything. Maybe is Ripple's position, well, we think you're entitled to this, but nothing else. I don't know. But shortly after I find out what their position is, then I'll probably have to ask permission from the court to allow me to have access to review certain non-public materials.
Got it. Well, what about XRP holders as amicus being included?
Well, that's what I'm talking about. It would be right. It would be us asking her, all right, you said that you grant us amicus status and you want to hear our meaningful perspective. In order for me to do that, you know, I have to be privy to certain things, right? Like I'm right now as amicus counsel, I'm only privy to what everybody's privy to. So, you know, I haven't read the unredacted Hinman deposition. I haven't seen these experts, right? They don't file their reports or their deposition testimony in public. So is there an XRP holder expert who's going to say, you know, in my opinion, the average XRP holder would have did this, and did this before acquiring XRP, and therefore they would have had to know about Ripple, and they would have had to do this and rely, you know, all those things. Is there a person out there like there was in the Telegram case? Well, if there is, how can I address that unless I read, you know, his swag opinion?
That's interesting. And who would that individual be? What would that person look like?
All I know is that there's 16 experts, right? 8 on each side. We know of the Mets guy. I don't know for sure who the other experts are. I did look at the Telegram case, and I read the report of Patrick Duty, who was he was retained by the SEC to give an opinion as to what the average reasonable gram purchaser would have relied upon when purchasing grams. So, but anyway, so I wish I could do something, you know what I mean, with the judges and say, hey, this isn't fair. But when both sides are coming to her saying we agree, we're not a party. There's just nothing we can do about it.
Yeah, we wouldn't want to have an interruption anyways, you know. So, you know, it looked bad, like you said, on the part of the judge, but then also on the part of the main defendant, you know, in this case, which is Ripple, which could, you know, then detrimentally impact everything that's you know kind of going on right now. Is that how would So, because I'm looking at this, obviously there's, I look at the commentary and, we see, people are so up in arms, about everything going on. And like you're saying, now's the time for us to sit back and, we have to have more patience. But
Yeah.
this extra year of patience, really, at the end of the day, we're 10 years into this crypto experiment, or we should say this, which is, as we talk about even, our constitutional republic, here in the United States is still based, could be referred to as an experiment. It's gone on, and but here we know the direction we're moving in. So an extra year of patience to make sure that this whole case kind of unfolds, in a meaningful, path, I think is the end of the day could be good. Not,
Yeah, I mean, listen, I understand why people are so upset, right? I get it. I swear I do. Like I said, I didn't think the schedule would be this bad. You know what I mean? And I'm in this business, so for someone who's never in this business, I can only imagine how outraged that they feel. But what we have to do is use our efforts the best we can. So, for example, I've had a few DMs with guys, gals on Twitter, right? Because you don't know who they are. Say, being critical of me, where you're not doing enough and doing this, and I'm like, okay, well, have you reached out to your congressman via Connect to Congress? Nope. If they're international, have you went on the international petition and signed it? Nope. All right, so all you're doing is complaining, right? So if we change the Congress, for example, and we get these people that I'm having meetings with and they become in power, and I can go to them and say, here's 50,000. Right now we have 21,000 international XRP holders who signed the petition. That's a lot, and that's great. But if we got 50,000 and we had 100,000, people pushing for this, we could get an investigation. And I'm telling you, these people who think they got away, right? Who are arrogant SOBs who think they got away. I'm telling you, what they fear the most is subpoena. And when you can get their private emails, look at the emails that have been uncovered from Empower and Jason Foster, and that's on a government email. That is Bill Hinman and the SEC going back and forth saying, hey, you can't have any more meetings with your partners, dude. And then you notice Bill Hinman says, let's talk about this live, right? Let's stop putting. Now imagine the private emails, the Google emails, or text, some other server, or text messages. When you can access that information, that's when this thing blows up. And I believe there will be the smoking gun, because I believe there was insider information. And I believe that people, were acting on it. There's too many people who appear to be clairvoyant.
Oh yeah,
right?
The shorts.
And who can predict the future. And so as frustrating as it is, just I'm telling people that's how you do it. You write your congressman, you write your senator, you let them know, you keep the pressure up, and you do everything that we can do. If you want another protest, we organize another protest at the SEC. But for everybody who says they're going to get away with it, and the system's crooked and the judges are crooked, well, there's nothing I can say to you. You know what I mean? Because a lot of people are attacking the judges as well. Listen, a judge can't dismiss a case unless there's a motion to dismiss filed.
Right.
So if Ripple doesn't come to the judge and say, hey, look at all these conflicts of interest, throw this case out, the judge isn't following me on Twitter. You know what I mean?
Well, yeah, or no.
I mean, maybe the judge is, we can't assume that the judge is subscribed to On the Chain or DAI and knows all this information. And so unless there is something in the record by the parties asking them to do something, they're not going to do. You know what I mean?
Plus, the judge already has a pretty solid work. He's got a lot going on right now, and people think, oh, they're just doing one case. They're doing a lot. And if you sit there and start dissecting some of those opinions or anything filed by the court, yeah, of course they have. They're not doing it by themselves. They have aides. There's people that are working in their office, but they're generally steering it. This is a question that came in here. with charity.org. Big question for you, John. Once the XRP holder's brief is filed with the court, will we be able to read it?
Yes. Yes. We will be able to read all the summary judgments and all of the Daubert motions, except for obviously if a party designates certain thing confidential, then they can redact it. So only the parties see it and the judge reads it, but the public doesn't. But certainly Amicus brief, there'll be nothing redacted for me. And they'll be able to read it. And we'll all be able to read most of the summary judgments filed by the SEC and by Ripple, as well as their Daubert challenges. And so that's all public record. You know, when there's a contested issue, that's when it gets filed, motions and things of that nature. So, for example, when there was a motion by Ripple to force the SEC to answer requests for admissions about certain factors of the Howey test, and the judge ruled that the SEC had to answer some of them, everybody says, well, what happened to that? See, the SEC got away with it. No, the SEC answered it. The only reason that we would ever hear from it again is if Ripple filed a supplemental motion to compel because they didn't answer. The problem is we don't see that because it's not part of the public record.
Got it.
You know, the reason I can get the duty from the Telegram report is because it was filed as an attachment to a motion for summary judgment in the Telegram case. And so that's all public record.
Yeah. So I'm looking here. There's some other comments here, and I try to blend a couple of them together because we have one here, XYZ, with summary judgment early 2023. The end of the road is still near, just a little further than we thought. And then to kind of, tie it into here with Nelson Diaz, some market the fixes in. This won't end now until 2024. Gary's job is to delay it, which we talked about before. But you had mentioned, as we started, that we look December, maybe Q1, but this could feasibly be delayed, through 2024.
No, because for one, Ripple has agreed that despite the Hinman emails, they want to move for summary judgment, right? So we have an agreement in place now. The final briefing will be December. So if it takes the judge 90 days to rule, that takes us to the end of March. Worst case scenario, it takes her 6 months to rule, right? That takes us to June, the end of June, the end of the second quarter. Could she go longer than 6 months? Sure, it's possible. But then you have that 6 month rule that you have to report it to Congress and all of that. So I can't see Judge Torres taking, more than 6 months to rule. And so I'm confident to say that now if Ripple were to say, well, we don't want a final ruling until we get the Hinman emails, and then the Second Circuit appeal came into place, could it be, longer than that? Sure, but that's not the stance Ripple's taking.
So worst case, obviously longer than June, but we should look at kind of that June timeline potentially as things unfold. So really, we'll know more as we get to December.
Yeah, I mean, I just don't see Judge Torres wanting to report to the Congress that a case of this magnitude is still on her docket, 6 months after the fact. Yep. And I don't see her ruling faster than certainly no faster than 60 days, right? Because you're talking about massive amount of complicated information between the Daubert motions, and let's say the SEC is moving to exclude 2 of Ripple's experts or 3, and Ripple's moving to exclude 2 or 3 of the SEC experts. She's got to get through 4 or 6 Daubert motions. The SEC is moving for summary judgment pursuant to Howey. Ripple's moving for summary judgment pursuant to Howey. Ripple has the affirmative defense and fair notice defense. You take all those things together, there's just no way she's going to rule. In my opinion, she's going to take a full 3 months, to make that decision, and it could very well be 4, 5, or even 6. But I don't see her going further than that. Could I be wrong? Of course, it could be.
What about this one here? This is Alchemist says the case will never be over. XRP Twilight Zone episode. It's like,
yeah. I mean, I get that. That's how people feel, and I'm never going to criticize someone for feeling that way. It's demoralizing. I know people are demoralized, and I get it.
Well, there's 66,000 plus. Is it still 66,000, John, as far as representation, as far as people that have signed?
Yeah, it's 66,750.
We're almost at 67,000. It's
Right.
incredible.
Yeah.
And that, again, that was something probably nobody thought was going to happen either, which is pretty incredible. You think about that. You look at some of the bigger stadiums in the U.S., and some stadiums don't hold that many people. When you see that many people in one place at one time, with the pitchforks and the torches, they're not happy, because again, the one institution was their main mission was to protect the people, the investors. They sort of really missed out on that, and all we get from Gary Gensler is the one prong of the Howey test. He always brings it back to the one, almost like nothing else exists. He always talks about the that
you
you
expect
can't.
profits.
Yeah, exactly.
If you expect profits, it's a security.
If you expect profits from the work of others, then you are okay. Well, that's great, Gary. But guess what? There's the Howey test.
I mean, I know another big question was, the timing on the emails. I don't know if you guys are getting those questions. And I know it's a big part of people's frustration, and I get it, because it was a year ago that Judge Deaubert originally ruled that the Bitcoin, XRP, ETH documents, and the Hinman speech, all of that stuff's relevant, right? And need to be turned over. And so even in her recent ruling, where she said that the deliberative process doesn't apply, she gave the SEC the opportunity to invoke attorney-client privilege. So she's ruled on the deliberative process privilege and says that that's not applicable. But the SEC has, and I reached out to my friend Jimmy Filan to make sure I wasn't misquoting anything. He's the man when it comes to this stuff, and he said that her decision is due. The SEC's objections, or what they want to call attorney-client privilege, is due on April 29th. Ripple has 5 days to respond. That takes us to around May 7th. And then we got to wait for her ruling on those privileges. Let's say she takes a month. That puts us around the first week, middle of June. And then the SEC would have 14 days to object to Judge Torres on the whole matter. And Ripple would have 10 days to respond to the SEC's objection. That's another 24 days. So that basically takes us to somewhere between the 1st and middle of July before the decision gets to Judge Torres' desk. And we looked up her other decisions where Judge Deaubert has ruled and they've objected, other parties have objected to it. And she's been fairly fast. She takes between 30 and 45 days. So let's say worst case scenario, 60 days. If it gets to her in July and she takes 60 days to affirm it, then she would be ordering these to be turned over right around the beginning of September. Right. And then, of course, the question is the SEC going to ask her to certify an appeal to the Second Circuit? And if she agrees, then it's going to take another few months. And if she doesn't, then they could try some writ of mandamus and delay it out as well. And so on the Hinman emails, ultimately, if Judge Torres certifies an appeal to the Second Circuit, then the SEC can drag this out until the decision, basically. And that's why Ripple is wanting to move for summary judgment even without the emails. If she doesn't, then we could get an order that they have to turn them over probably around the time of December. You know what I mean? And so we'd have the briefing done, but not a decision from Judge Torres on the summary judgments. And then that's when the SEC would have to turn over all the emails. That's the best I can do. And again, I have to give credit to Jimmy for walking me through it.
That's awesome.
Awesome. Yeah, huge shout out to Jimmy finally.
Big shout out to Jimmy and to Jeremy Hogan out there. And, you know, John, I mean, you're doing obviously a phenomenal job out there. And so we got a comment here and then also a question. But the comment here I thought was great. He's saying, thank you for all your hard work, John. I appreciate everything you've done for the XRP community. You're a very selfless guy. And that I'm sure that resonates with pretty much everybody here, you know.
Well, I appreciate it. You know, hopefully, you know, listen, hopefully I'm hoping the judge doesn't certify those decisions, you know, to the Second Circuit, because that's when where I said that if they were forced to turn over the documents within 90 days of Judge Torres, I could see a settlement, you know, because they never want to turn those over. And at some point, I think they ultimately have to. The question is, can they run out the clock, you know, before a decision or around the same time as a decision? And that's really going to come down to the timing that and the decision by Judge Torres.
Right. All right. So here's a follow-up or here's a question. And I think we touched, you know, some of this a little bit earlier, but so the question here is, can we draft a notice of maladministration against Gary Gensler and put it out to all the XRP Army to sign and send Gary a certified mail to put more pressure on this guy?
You know, we can, and I encourage everybody, you know, I'll sign anything as far as, you know, criticizing him and trying to get him ousted. But I got to tell you, I'm firmly believe that Gary Gensler does not give a crap about retail holders of XRP, crypto, or anything else. I mean, the man is, you know, I reached out to him professionally in his office that just simply said, listen, go after Ripple all you want, but I've got 60-some thousand people that, you know, we asked to be sued because this is so extraordinary. Like, can you there's a way to do this where the retail holder doesn't get screwed. And like, they won't even acknowledge it. Like, they won't even acknowledge our existence. And so, you know, the man seems to be genuinely offended about the ability to collect interest from stable coins, and like, you gotta protect us from that, right? You got the Celsiuses and the BlockFis and the Nexos, and it doesn't bother him that a U.S. holder is missing out while international can collect 9% interest. You know what I mean? And
yeah,
and so he just doesn't care.
Doesn't care.
He just doesn't, and it saddens me to say that, but it's true.
But don't worry, he's so hip to the banks that they can give you. He put that office hours video out saying you can get 8% interest from the banks. I'm like, well, what year was that, Gary? You're $120 million sitting in the banks, not collecting 8% interest in any bank, and that latest, you know, having to be an accredited investor, like you just said, with the Celsius and BlockFis.
And there were there's been talks of them trying to increase the minimum thresholds of an accredited investor. And I mean, if there's any more oppressive rule than the accredited investor rule,
well, that's what happens when you're a Wall Street guy, ex-Wall Street guy.
I tell everyone, I didn't become an accredited investor until my mid-40s. You know what I mean? I served in the Marine Corps, and I'm just saying, my brother, he served in the Air Force for 28 years, has a master's in business administration. He's still not an accredited investor.
Well, that's it. I mean, they've stacked the deck against people. It's very unfortunate, and you're right, 100%. You know, Gary, you know, amongst others that seem to occupy those positions. They just have a lot of animosity, towards the public. And here's a direct parallel. If you look at Fauci and some of the statements that Fauci had regarding the court's decision versus the CDC, and Fauci came out and said the court doesn't have jurisdiction and that it's a CDC decision, but he forgot about the Constitution. And so here again, you have another government employee, and Fauci is a government employee, happens to be the highest paid, which is, unbelievable, different conversation. But now you have Gary Gensler, same thing, an employee of the government, representing as serving as the chair of the SEC, and again has the same type of loathing that Fauci has for people and for really the rule of law. And it's kind of mind-boggling.
Yeah. No, I listen, this whole case is an example of many things. Obviously, insider information, corrupt government officials lining their own pockets, all of those things. But when you think about it, guys, this case is so easy to settle. It really, honestly, objectively is. I mean, I've been reviewing the complaint again. It's probably the 7th time I've read the complaint since it was filed, because I'm putting together some information to send, based on what we're talking about, trying to gain access to information and going through the complaint. And their only real shot for them, honestly, is, Ripple sold XRP or gave an option contract of 1 billion XRP to certain investor for a certain amount of money on this specific day in 2014 or 15. That's their case. That's their case right there on that specific transaction. Because the ecosystem of XRP was so new, it was only Ripple, back in 2014, maybe they could make the case, right? It's not a slam dunk, but it's certainly better than trying to prove that secondary market XRP in 2022 is a security. Right? That's the case. And why Gary Gensler and them won't just come to the table and say, pay this fine for these early transactions and let's move on, is
right. It's
beyond me.
John, but is that because they don't want to come out and say, well, today's XRP clearly is decentralized? It almost seems like they don't want to give that particular one up. And you tweeted something out last week about 2 gems that we got from the judge, and one of them really had to do with the fact that something's beeping on my computer. But you as far as the fact that the judge had called or had questioned the counsel for the SEC, saying, what do you mean? Are you saying that everybody who ever purchased XRP is a Section 5 violation, is in violation of Section 5? Like, that's a pretty tall statement. And then also she made a statement too about the utility, right, having utility, and contrasting and comparing that with both ETH and Bitcoin, and saying, well, it has utility and has a currency. So that were 2 big gems that you had called attention to, which I thought was pretty amazing.
Well, it's the first one is going to be the lead in our amicus brief, because the SEC, they say, hey, we're not claiming that, it's Deaton's interpretation. That's what they say. We're not claiming that every XRP in the world, is a token. That's not what we're claiming. And then, of course, they claim that. But the judge herself called him out and said, based on your theory, every single person in the world who sells XRP has just violated the Securities Act. And not just that, but Judge Torres, in her decision where she did grant us amicus status, she acknowledged something. A lot of people didn't catch this, but she said, if the movements, and she's talking about us, XRP holders, if the movements are correct, no, she said, even assuming if the movements are correct and this complaint and the SEC's allegations are as far reaching as they claim it is, and then she went on to say they're still not parties, right? And so I'm going to give them amicus status. But that's her recognizing that this theory, this absurdity that they're claiming. I mean, I read through the complaint, guys, and there's a section there where it says that they cite where Joel Cash, David Schwartz in 2016 was asked a question that if Ripple folded up, would XRP make it? And he said, unlikely, or something, words to that effect, right? Like that's the allegation. That's 2016.
Right.
So like one of the things I'm asking for is, okay, if you're claiming that today, where's the proof? Where's the proof that if Ripple folds today, are you claiming that XRP is worth zero and worthless and is untradeable? You know what I mean? That's what I'm getting at. And so it is the most absurd position that they could ever take. And it's frustrating because they don't have a good faith basis to make this argument, yet they're making the argument. And even though the judge has called them out on it, even though Judge Torres has acknowledged, yeah, these guys are saying that this is the most far-reaching, overreaching complaint in SEC history, we have to wait all this time to present our case. And so that's why I mean that I get everyone's frustration. You know what I mean?
Yeah, and really at the end of the day, and you brought this up, but for the SEC to even enter into any kind of settlement talk right now, they would have to drop, all of the hatred, towards the general public, in terms of the retail investors. They would have to then, take themselves off the pedestal. But at the same time, it just seems like, they're so, I'm not going to say, if you go into, a legal argument, the parties are going to be far away from each other, and settlement obviously is trying to find some commonality, and trying to minimize, detrimental impact moving forward, so, but in this scenario, the parties there doesn't seem that there could be an intersect because of the tension that we're seeing on the part of the SEC that they will refuse to acknowledge. They want to acknowledge, if Gary Gensler and his office doesn't acknowledge us on the retail investor side, just a small acknowledgement, how are they going to even come to a settlement? That's why, I firmly believe, just looking at all the politics of it, it has to go to judgment. It seems like they're never going to back down.
Yeah, well, I mean, the real sticking point, obviously, is that what Ripple actually needs for a settlement is they actually need a Hinman-like declaration, right? Hinman declared Ethereum, present day Ethereum is no longer a security. They would need some kind of agreement that there would be a consent settlement agreement, and it would get blessed by the court, where there'd be a statement that although, Ripple is admitting to, early transaction sales of XRP and paying a fine, that ongoing and future trades of XRP are not considered securities per se, or something like that. And I agree with you, Jeff. I think that they're just saying we're not going to do that, or we refuse to do that. And that puts Ripple in the position of, if all there is a fine of, let's just pick a number, $50 million for early sales of XRP, and that's it, nothing else is said, there's just no way Coinbase and Kraken general counsels are going to call the CEO and say, oh, let's list XRP tomorrow, right? Because there's no, especially when they think they're already in the target zone of Gensler. Are they going to go out of their way to relist XRP when they already think they may be a target of Gary Gensler? It's just never going to happen. You know what I mean?
Yeah, I want to get to a couple comments here. This one here, DJ Jarvis says, hey, don't get upset, grow up. This is the judicial system. We should be grateful that the case is going in Ripple's favor so far. We're damn lucky to have Mr. Deaton fighting on our behalf. So that's a really good comment. There was another one too that I saw here. This one was very easy. Hydroponics Alan, he says, thank you for fighting for us on your dime to get justice for all XRP holders. God bless you, brother.
Well, thanks. I know someone tweeted. Actually, everyone's usually very overwhelmed. I get overwhelmingly positive messages, but obviously you get
some
everybody
detractors
gets
in there.
But somebody said something about Ripple lawyers in Deaton are making a fortune. Like, dude, I wish I could build Ripple.
Oh boy. It's so funny that the best thing you like about crypto Twitter is everything's an assumption. It's like you use the word instead of the. Therefore that must mean they just go on these crazy tirades.
Yeah.
And
someone said, oh, the notoriety you're getting is leading to more clients. I'm like, I haven't gotten one more mesothelioma client since this all happened.
Right. So that's what's weird. But you got
I haven't had a mesothelioma client call me up and say, hey, I own XRP and I got meso, man.
Yeah, but maybe you got some more people you could defend some more people against the SEC. That would be the if that ever rolls in. But
yeah, I mean, I've gotten a few phone calls and I talked to this about with Jeremy Kaufman, as you guys know, from LBRY, and I said, as sad as it is, I'd say it's malpractice to advise your client to cooperate with the SEC right now.
Mm-hmm.
And think about that. I'm a licensed attorney, right? And I just said that it would be malpractice, in my opinion, for a company to fully cooperate with the SEC, to go in there and say, here's our business, here's how we make money, here's all the dollars that are spent where they're spent. Instead, I would say, tell them to get a subpoena. We'll honor a subpoena. We'll honor search warrants, and we'll do all those things, but we're not cooperating with you at all. That's very sad. That's very sad to say that.
It's a crazy position that we're finding ourselves in. We always say that feel like we're in some sort of an alternate universe, that, a little over a year ago, things were kind of moving along a certain course. And then all of a sudden something shifted. Now, nothing makes sense anymore. But let's say, November rolls around, different political climate. Let's say they pass some legislation that is crypto friendly. They create some some rules of the road, so we have a little bit more clarity on what may or may not be deemed a security. Potentially, maybe also looking at the CFTC having a little bit more jurisdiction than the SEC. So and we're just in a what if scenario, because we might get we see a changeover politically and they drag their feet, still nothing happens. Well, let's say something does. We're hoping that we're going to have a better political climate for that. Does that have an impact on the case if they have some sort of regulatory clarity, or does that make it easier for a settlement?
Oh, it makes it much easier. I mean, it depends. The devil would be in the details and how clear, if you got something like, let's take an extreme scenario in our favor. If you got something like what the UK's FCA did, where they said, listen, we're going to evaluate these tokens, and there's a security token, and there's an exchange token, and there's utility token, and they evaluated XRP, and they said XRP is a hybrid token between a utility and an exchange, but not a security token. If it was that specific, then it would trump this case, right? Because that's Congress, that's the new law. If it wasn't that way, and it was just more, vague, positive, but vaguer than that, then it certainly could be used as a settlement, especially if the CFTC was designated as the agency that will oversee this industry, if you will, or these assets. If something like that came out, but as a case that's already in the system, it would have to be really specific, and XRP would actually have to be designated non-security by Congress to completely usurp the court.
Look at this. So Crypto Bag Boy says, do you think Uncle Gary, JJ, and Billy Boy will ever be held accountable?
I think that there is a good chance, if and only if we can get an investigation and an inquiries into that. I've said it for a long time that I thought that there was a lot here. And when we see these emails where the SEC's ethic office sternly is telling Clayton that you could be in violation of the criminal contempt, criminal conflict statutes. You have an ongoing profit sharing relationship with your firm. You are not to meet them again. And he continues to meet them, right? Again, that's what we know. And so I'm confident if we get an investigation, and that's when you're going to see the rats running, right? When you blow something up and people get subpoenaed and you're starting to get into the evidence that I think may exist, who do you think is going to rush for immunity first?
Right on.
Everybody started, listen, I'm a former federal prosecutor. Let me tell you, that's how it works. The first one through the door is the first one that gets the immunity and gets to walk, especially if there's, any quid pro quo information. And I'm not saying there is, but it's looking more and more like that, as each day passes. And so, but we have to have that, if I believed I could file a lawsuit against those guys, including a civil conspiracy involving certain other people, not just Hinman and Clayton, and be able to get into the discovery phase where you can issue subpoenas against them and get emails and bank records and things like that, then trust me, I would do it. And so we just need more.
Right.
To be uncovered, and that's the way to do it. So if everybody just throws their hands up and says it's a corrupt system, it's always going to be corrupt, and there's nothing anybody can do about it, then the answer is no. If people keep the pressure on and we get a change in Congress, we get a change in the Senate, and we get people having hearings, trust me, it becomes a different ballgame.
Right on. This one here from Dash. Thank you, Chip and Jeff. Excellent interview. Thank you, John Deaton. We are all in your debt as XRP holders, and Jeff and I feel the same. It's great, and we're coming up on 1 hour here, so I want to be respectful of your time. Jeff and I do as well. And I don't know if you want to just any last words. I mean, that right there was a pretty good call to action, right? Never let things sit. Never let something that happened. If you're okay with it, that's fine, but don't sit there and complain about it, right?
Listen, here's the thing, right? We either do something or we do nothing,
right?
And so when people ask, do I think that justice will ever be served? The answer is I don't know. Like, I just don't know. All I can do is try to force the issue, right? Because we can't have our government agencies and the officials, the directors of corporation and finance and the chairman, we can't have this system where they just ignore their own ethics office, right? They just flat out ignore them. And they do it because they're so arrogant, because they can get away with it. And why can they get away with it, guys? Because people say, there's nothing that we can do about it. Well, listen, it's a democracy. If we accept corruption, we're going to get corruption. And so exactly. I don't want to accept it. So I'm going to keep fighting. And if every door gets slammed in my face, and I'm going to go to the next door until there's no doors. And if that's the end result, then that's the end result. But I'm not going to say, oh, well, there's no use trying, because nothing gets done if that's the attitude we take.
That's
well
awesome.
said.
You've got 66,000 people out here willing to help out in any way, and we've got the crypto investigator here who said, "I'll help out in any way, John. California licensed investigator, willing to travel. I'll pay my own way. Serious about that, and XRP holder for 2+ years as well. So." There's a lot of that. We get a lot of comments.
XRP holders, I honestly believe they're the best. Every group has certain individuals, right? But as a community, I I think they're fantastic, and I think that they're more educated than the average. I always say I'll take the average XRP holder versus the average Bitcoin maxi any day.
Right. Like, I second that. Well, listen, I mean, I don't know if there's anything else. John, as always, you know, and the most amazing thing to Jeff and I is that right after you filed the first paperwork in January of 2021, early days, you know, we asked you to come on the program. You've always been fantastic about coming on here. I don't even know what appearance this is, but we've been on quite a bit, and it's always great when we ask you to come back. So, you know, from Jeff and I, thank you so much for coming on here, and also for the XRP community and the On the Chain community as well. So we thank you for gracing us with your expertise. I mean, this is what we want to hear from and hear about. And great, thank you for spending the hour with us.
No problem. Thanks, guys. It's always a pleasure to be on. Hopefully, next time I'm in Florida, we can go to dinner.
That's the second time we missed you, by the way. You were down here last year. We missed you, but it was Jeff and I were so busy, and you were busy, and
we'll get it. We'll get it done.
But we will get it done. And the next thing will be us, three of us smoking a cigar, having a toast and a beer, and we'll get a selfie of all of us, and that I can't wait for. That'll happen.
Thanks, guys.
John, thank you for being here with us. It was awesome. I also want to give a quick shout out to the community out there, all of our supporters, everyone that supported tonight, as well as the OTC members and subscribers. We have the best and the brightest, and all YouTube. And John, it was a pleasure.
Thanks,
guys. We will see you on the next one. Chip, Jeff, and Deaton, the Deaton superhero, the Deaton out.
The Deaton.
Are you down with OTC? Please like, subscribe, and click the bell to be notified when the next video drops.